on most of it, and we are approaching 12:30. So now, the legal context in Canada, there's generally 4 land types for carbon projects in Canada. There's public lands, private lands, treaty lands, and reserve lands. When we're talking about Aboriginal rights and title, in many ways, reserve lands are the most simple. As with most resources on reserve lands, generally the Crown holds land as fiduciary of the bands. Projects are possible on reserve, but as everybody here knows, reserve lands certainly do not reflect the traditional territory of First Nations, and instead reflect postage stamp-sized portions of those traditional territories. So that limits the project size. You can't implement a 5,000-hectare forest carbon project on a 50-hectare reserve. INAC permitting, as always, can also cause significant project delays, but ultimately can grant authorization to carry out projects on reserve land. So what I'm going to do is I'm going to focus on the first 3 types of land in a legal context discussion, as they're the more complicated ones, and they also help us look at the unique issues that First Nations face. So, in developing a carbon project, resolving title is a key component to creating carbon offset. So, in the context of forest carbon, this presentation assumes that a carbon right in a tree is owned by the owner of the tree. And it's not necessarily settled that this is the law, because carbon law, to the extent that it exists, is entirely new, but it's likely the better view, largely because, if it isn't, there's a really messy constitutional debate about who owns carbon. So, under the common law, trees are real property, and they're part of the land until they're harvested. There's certain exceptions to that, but for the most part, this statement is true. So in order to determine ownership of carbon in trees, the first step is to determine who owns the land. And this is where the law relating to Aboriginal title becomes important. There's many competing claims to ownership of forest carbon and forest land. There's provincial government, there's tenure holders, and there's First Nations. And in this context, right now, we're just talking about public lands, so Crown lands that aren't privately held. In general, everyone in the carbon markets are behaving like the province owns the forest carbon on provincial Crown land. And an example of this, which Terry's familiar with, is the initial Ministry of Forests and Pacific Carbon Trust Forest Carbon Protocol, where the province was willing to assign ownership of carbon to persons carrying on approved carbon sequestration activities. So that was premised on the assumption that the province itself owned the carbon. But I think there's an open question as to whether this is the case. As you probably all know, Aboriginal title has been described by the Supreme Court of Canada as an encumbrance on Crown title, and that was the Haida decision. It's also been held by the BC Court of Appeal by BC courts that Aboriginal and title includes ownership of timber and other resources. So based on decisions such as Haida and Chilcotin, the Crown doesn't have clear title to forest carbon on Crown lands. In the very least, there's an element of First Nations ownership arising out of outstanding claims of Aboriginal title. And the Supreme Court of Canada has described this as an encumbrance on Crown title. So where Aboriginal title has not been extinguished from a project development perspective, outstanding First Nations claims are a project risk for developers, and they must be addressed in the due diligence project. In other words, a developer of a carbon project on public Crown lands or provincial Crown lands cannot claim clear title to carbon without first addressing outstanding First Nation claims to Aboriginal title. And when you look at other natural resource industries, such as mining, there's already an increased focus on the question of how have Aboriginal interests been addressed. If a mining project was going to be financed, one of the first questions the bank would ask is, what's the relationship with First Nations, what consultation and accommodation has been accomplished, and have the First Nations consented to this activity. And to go back to the the issues and the concerns of previous speakers, work really needs to be done here from an advocacy perspective to educate regulators, standard makers, and markets about the existence of Aboriginal interests and claims to carbon and carbon rights in Canada. So the bottom line for public land forest carbon projects is that any dealings with carbon on public land, at a minimum, engage the Crown's duty to consult and accommodate. So again, in the context of a forest carbon project, in order to carry out, say, improved forest management activities, you would need, in British Columbia anyway, a tenure under the Forest Act in order to access the public lands for forestry purposes. You would need permits and approvals under the Forest and Range Practices Act in order to carry out forestry management. So, consultation would be required to occur at that stage. Where there's an unresolved claim to Aboriginal title, in addition to any requirements to consult and accommodate, there's also likely an unresolved claim to ownership of forest carbon. And so what this means from a First Nations perspective, until this issue is actually addressed in the courts and there's some certainty over, exactly what the Aboriginal interest in carbon is, it means leverage over other competing interests, such as the government, project developers, and forest companies. First Nations should and must be involved in carbon projects from natural resources such as forests because of the impact of it, because of the importance of natural resources and how they are tied in to claims to Aboriginal title. But again, the provinces have been slow to recognize Aboriginal interest in carbon, and advocacy work needs to be done to change this perspective. Private land is a slightly different situation. Aboriginal title claims are not necessarily extinguished by Crown grants of private land. So when the Crown gave private land to current private land owners, Aboriginal title was not extinguished. The reason for this is a jurisdictional issue. Provinces don't have the jurisdiction to extinguish Aboriginal title. And this is especially true with respect to large parcels of private forest land, where BC courts have suggested that if there's a Crown decision relating to forest land, even if it's privately owned by a forest company, consultation and accommodation is still required. So what does this mean for forest carbon projects that aren't on public land but are actually on private land? Well, it means if there's any Crown decisions relating to these projects, at a minimum, the Crown's duty to consult and accommodate First Nations is still engaged. Where there's an unresolved claim to Aboriginal title, it also likely means that there's an unresolved claim to ownership of forest carbon, and that private landowners do not necessarily have good title to forest carbon. And this goes back to the due diligence requirements of project developers. If they are creating carbon offsets and want to tell the world and their customers that they have clear title to these carbon offsets, they need to be, at a minimum, working with First Nations in the area of those projects to resolve the outstanding claims to forest carbon. So again, for First Nations, this means leverage over competing interests. And again, the provinces have been slow to recognize Aboriginal interests in carbon on private forest land. Carbon standards generally, and there's a few exceptions, but generally, carbon standards like ECS or CCAR tend to recognize private land title to forest carbon without considering Aboriginal claims. So if somebody has fee simple ownership in land, BCS will likely issue them an offset or carbon on that land, even if there are outstanding adverse Aboriginal claims. And again, there needs to be some education and advocacy with standard makers to tell them that that's not necessarily the case. On treaty lands, where there are treaty rights, the analysis is largely the same. To the extent that Aboriginal title is extinguished by the treaty, then you need to look at the treaty to see what language there is around ownership and control of forest resources if you're dealing with forest carbon or other resources.